The next case is Vince Alvarez versus Anna Christina Plana. Thank you.
Good morning. May it please the court, counsel. My name is Audrey Harris, and I'm here today on behalf of the appellant, Vince Alvarez. There are a couple arguments set forth in our briefs, but primarily I want to direct the court's review to the first argument that we set forth, which is the classification of the Smith-Barney account as a marital asset. The final judgment reflects that
when your client puts the money in both names in the account, what does that mean?
As he testified at the trial, he did that due to some recent health issues his father was having, and it prompted him to think, well...
No, the judge didn't believe anything he said, right?
That's correct. And
okay, so forget about his testimony. Just let's look at the fact that he took an account that had his non-marital money, and he went to the bank and added his wife as a signatory on that account, made it a joint account. What is the significance of that?
Well, you have the only other testimony on this account was from Matt Bridge, who managed the account, and Anna Alvarez, the former wife. And their testimony, even though the lower court didn't believe the husband, was consistent with his testimony. The former wife testified that...
How would you, if I wanted to give my wife a gift of money of an undivided 1/2 interest in an account that I had in a bank, couldn't I manifest that intent by putting her name on the account? Isn't it a reasonable inference that by putting her name on the account, I intended to give her a gift?
No, it's not a presumption.
How about if I know it's not a presumption? I'm just asking you if it's a reasonable inference. How about I got this 1967 Corvette with a 427 in it, and it's mine. I had it as premarital property. The title's in my name. And one day I go down to the Department of Motor Vehicle and I say, I want to put my wife's name on the title to my prize car. Couldn't a judge, viewing that evidence, reasonably infer that I intended to make my wife a co-owner and therefore bestow upon her a gift?
On your example, because it was an actual vehicle, I would say yes.
Well, why is the account any different?
Because this is liquid funds.
Right.
That...
he doesn't want to take them out of the bank and hand her half because he wants to keep the money invested, right?
He didn't relay to her that this was a gift to her. Certainly, if he had intended a gift, we could also presume that... Wouldn't he tell her?
Well,
hey, I've gifted you
supposing that he had gone down. Supposing he had gone down to Smith-Barney and told his broker, "I want you to take this money out of my name altogether, and I want you to put my wife's name on the account." Is that in and of itself sufficient evidence that he intended a gift, or is it still his non-marital funds?
If he completely took his name off of the account, it would be her funds. If he completely removed himself from that...
He didn't tell her? She didn't even know he put her name on the account?
If he completely removed himself.
Completely removed himself, put her name on the account. That's a gift.
I would say that would certainly look more like a gift than what we have here.
Well, is that enough evidence in and of itself for the trial judge to find that there's a gift, even over his testimony that, well, I only did that because I had, a bunch of creditors out there and I was afraid somebody was going to levy on my account or garnish my account, and I wanted to make sure that, the creditors couldn't get it, so I put it in my wife's name to protect it from my creditors. And the trial judge says, well, I don't believe a word that you said, so I'm going to find that there's a gift. Do we reverse that or do we affirm that?
In those limited circumstances, I would say that looks as though it's a gift. Mm-hmm. But certainly, title alone, this court has a line of cases, including Crouch, which is very recent, very factually similar. The wife's name was on that account too. It was jointly titled. No dispute. We have a jointly titled account. an account the wife didn't even know about until discovery
Well,
during the divorce.
Crouch was bound by Archer, and Crouch didn't, apparently the judges on Crouch didn't like Archer, because they said they thought we should recede from that rule, right?
Well, there is a distinction between real and personal property, whether the rule should be the same for personal property as it is for real property. When you
No,
have real
but
property, there is
didn't the
that
Crouch
distinction.
court say that they thought that there should not be a distinction and that we should recede from the distinction that we announced in Archer?
I don't know if that was the majority opinion in Crouch or if it was a concurring opinion, but I do recall such a statement in one of those cases, yes, sir. But the law is as it is in Crouch and as it is in Archer. This is personal property. This is not real property. This is how can this be distinguished from Crouch? We have the same set of circumstances. Even if you discredit the husband's testimony, we have testimony from the wife and from Matt Bridge consistent with the fact that this is a non-marital asset.
Who has the burden of proof? Forget about the presumption. There's no presumption either way. Who has the burden of proof as to whether or not an asset is marital or non-marital?
If there is no commingling, it would be the opposing party. And the lower court did find in this case that there was no commingling of that asset. So the Crouch case indicates that the burden was then on the wife to show that a gift was intended. And that's where it failed here. We have undisputed there was no commingling, but yet the trial court said the only way the former husband could prove that the account was non-marital was to show that he did not use any of the assets for the marriage.
How about the case of a car? That's personal property, so the real property rule doesn't apply. There's no presumption. Let's say that a woman brings a car into a marriage, and after she gets married, she titles it as joint owners. Who would have the burden of proof on whether or not that's marital or non-marital?
It's difficult to say because, of course, we don't have the commingling. We don't have a car.
We don't have the
that's
lack of commingling.
Yes, lack of
They
commingling.
were both co-occupants of the car
Yes.
throughout the marriage.
And
They went and got groceries in it and all that.
in that situation, I would have to fall back on the case law that says title alone is not indicative.
I know that. I'm with you on that. Title alone is not sufficient to establish a presumption. But the trial judge still got to decide whether it's marital or non-marital. Who bears the burden? In other words, if the trial judge, is sitting there and he somebody's got to have the burden of proof, don't they?
Yes, and I would say it would be on the opposing party, the party intending to show that this asset that you owned prior to our marriage was intended as a gift to me.
So you're being consistent at least.
Yes, sir.
Why
burden is on the opposing
wouldn't
party.
the burden be appropriately allocated to the person who is seeking to defeat the naked title? In other words, here's a car, it's titled in both names. Why shouldn't the party that titled it in both names have the burden of coming forward and showing that the court should ignore the title and treat it in a different way?
Well, why should he have that burden if he can show that I had this asset prior to the marriage and I never mixed it up with anything else?
I don't know, you
Isn't that enough?
answered my question with a question.
And yes, and that's why he should not have the burden, because he has already shown that it existed prior to the marriage and I didn't commingle it with anything. What else can he prove? If it was intended as a gift, then okay, the opposing party now comes in and says, okay, well, it may have existed prior to the marriage and it may not have been commingled, but you still intended to gift me half. If there aren't any further questions, I would reserve my remaining time for rebuttal.
Thank you, ma'am. Ladies?
Your Honor, she had an agents for the appellate. I think that we had decided we're going to rely on arguments in our brief and not take up any more time.
Okay. Thank you very much. Of course, stands in recess.